I've also made a $90 payment to child support as soon as possible. I think that was the topics. I'm sorry, my pregnancy brain is getting really bad.
I don't think she's made a payment. She says she's going to make a payment ASAP, and a $90 payment is not cutting it. There's choices being made of I'm going to watch my boyfriend's kids instead of work a job that's going to pay me sufficiently or work enough hours.
We are here to review the amended tax return
and payments.
So
we're really in the same position that we were the last hearing. The court entered the contempt back in late June, ordered Ms. Stockwell to file her amended tax return, to file a copy with the court, provide me a copy. That has not happened. There's no evidence of her attempting to make that happen, of her making any efforts really whatsoever. I do not see that at least anything that she's filed indicating that she's making payments. So really we have zero progress and zero attempts at progress. And again, in a case, and if the court will recall, my client tried to prevent her from filing this tax return wrongfully back in January. We waited, we made lots of efforts over about 6 months to get her to comply. She just was obstinate and refused despite a very clear order. We're really in the same position. There is no excuse on this one for something that's really straightforward. It is taking time and money out of my client's hands and out of the hands that are the ones that are responsible for feeding and caring for the children. So kind of similar to the last case that you heard, my thought is to kick it out 2 weeks, but if it's not done at some point, the rubber's got to meet the road and jail time is appropriate. I don't want to do that. I want compliance. But if Ms. Stockwell is just going to ignore the court's order, I don't know what other options we have.
Ms. Stockwell, can you update me on the amended tax return?
Yes, Your Honor. I did get that tax return amended on the 9th. In the wee hours of the morning, I was working on it over the weekend after I had dropped off the kids from my visit. I did get them amended, but after amending them, I was left with no money for gas money to get back down to file in the court system or to present Ms. Baldwin's office with a copy of this. I've also made a $90 payment to child support as soon as possible. I had to wait for my check to hit last week for that to go through because again, we were in the hole and didn't have money to be able to get down and get any of that or to put any money forth for child support. And I think that was the topics. I'm sorry, my pregnancy brain is getting really bad.
All right. And I'm assuming, Ms. Baldwin, you haven't seen any payments come through at this point are these payments going through DCYF?
Yes. And so my concern, very similarly, I'm going to throw out my hands and make excuses. Those excuses just really fall flat. I couldn't get down there for gas. I have email. I have mail. The court has mail. She could, if she says she did it on the 9th, we're 9 days past that. She could have put it in snail mail and we'd all have it by now. I mean, she did, which leads me to suspect that she hasn't done it. So again, the concern there just isn't an excuse to not have, paid 60 cents for a stamp and put it in the mail. And so no excuse there. I don't think she's made a payment. She says she's going to make a payment ASAP, and a $90 payment is not cutting it. Again, there's not any excuse that she has. The child support order is, I believe, $480. And hey, I'm going to pay what amounts to a 20% of that isn't acceptable. She's not providing you any sort of plan for how she's going to even pay current support. It's just, I'll pay what I want to pay. That's not what the order is. You have to pay the court ordered amount. And so again, we just have somebody who says, I'll do what I want. And that is not appropriate. And so same request over 2 weeks, she needs to provide it. And if she doesn't and doesn't start making real payments, then jail time seems to be the only option to get her attention. Not what I want, but when people just sort of thumb their nose at the court, at some point we have to get their attention.
Unfortunately, the $90 was garnished from my paycheck and was half of my check. Therefore, we do not have the money to put forward yet. My husband does get paid this week, and we can put more towards it. But I have paid as much as I possibly can up to this point, as again, with all of the bills and everything coming in. I am more than happy to provide proof of our bank statements or anything needed. And I have contacted Mr. Gilliam to get an email to send those, and he has refused. So I have not been able to email Ms. Baldwin. I can't find it online. I've looked in many places. And I'm not making excuses. I'm genuinely trying to do this. This has been a very big stressor, and I'm doing my absolute best at picking up shifts at work. I'm trying to do odd errands for people to make up money to be able to pay the child support.
I'm assuming Miss Baldwin would be more than happy to give you her email address right here and right now if you have a pen and paper.
Yes, I do.
If she has it, I can just put it in the chat. It's probably easier.
For that, are you able to see the chat if that, Miss Stockwell?
Yes.
Okay, so
It's there.
Miss Baldwin's going to send you her email through the chat. I'd ask that the amended return that you said was filed on the 9th of July, please provide that to her via email. And if you can put that, if all you can do is mail it to the clerk's office, mail it to the clerk's office. That address is readily available online. We're in a situation where, I mean, I don't know, I know that you're currently pregnant, is that correct?
Yes, I am due on the 2nd.
And the last thing we want to do is put you in custody, but you have obligations to other children that are still, that are here already in the flesh, and we have to be considerate of those children as well. So we'll set this to the 1st. You need to provide email Miss Baldwin by Thursday, the 20th, close of business with that amended income tax return, and please mail it to the court, the Superior Court Clerk's office, and then we'll review this on the 1st at 1 o'clock.
We do have Ms. Stockwell present. So she did file a response. That response indicates, at least sufficiently to me at this point, that she has filed an amended tax return. That was one of the issues we were on for review. What's not happening is rational child support payments. It continues to be sort of, I'll pay what I want to pay, and that's the concern. Again, there's choices being made of, I'm going to watch my boyfriend's kids instead of work a job that's going to pay me sufficiently or work enough hours to be able to pay my quarter obligations. What I'm proposing, I do recognize that Ms. Stockwell, last we were here, indicated she was pregnant and due essentially now. So what I'd like to do is set this out 4 months. That allows for a reasonable period for that pregnancy to complete, come to fruition, for her to have some maternity leave and come back to work. I think that that's reasonable because at least we've solved the tax issue. But at some point, Ms. Stockwell needs to understand the order is what it is. It's not pay what you want, when you want, how you want. Second, I'm asking the court to award fees of $500 because again, we've had multiple hearings. It's reasonable that we have fees, and then if Ms. Stockwell signs that order, then we'll enter it ex parte. If she doesn't, then we can address it at a date 4 months from now. I don't have any issues with that. I don't want to create an additional hearing for my client.
All right. Ms. Stockwell, any comments?
I would like to address the whole boyfriend's kid thing and the not working thing. I had my hours got cut due to pregnancy related issues. I do have a note finally from my midwives regarding that. I can send it over to Ms. Baldwin. It cut my hours down to like 19 a week, and then the garnishments have been half of my checks per the regulations of they are only allowed to garnish half of the checks. The rest has been going towards food to aptly feed everybody here. And then I also made sure that there was going to be an extra payment this month. I believe it was of $330 added on to it. That came from a settlement with an accident. They had told me it was going to be in by the 25th. So my declaration, I did say it would be there by the 25th. It did take a little bit longer, but it did get put in. And I don't see the need for us to be paying the $500 to him or to the lawyer fees when he's been able to work full time and been able to acquire the lawyer and all that. I understand that the frustration and the taking time out of everybody's day and everything. I get that, and my apologies for it being this long. But my hours had been cut. I got back to working at least part-time hours. And then I wanted to ask what exactly we could do while I am on maternity leave to lessen the burden of me potentially have to going back like 2 weeks after I have the baby for the child support.
Briefly in response, this is not we brought this contempt because she didn't pay a payment. She didn't pay anything from the date the first child support order was entered in November of 2022 until we brought the contempt. This was somebody who just said, I'm not gonna pay. And then even after the contempt, what we see are these like $90 payments, these payments that are not even close to what the child support order is. So this is not something that's, and has been an issue for the last month of her pregnancy. This has been an issue that's 6 months long. So we did not race in here to do this, but at some point she needs to pay as ordered. It is what it is. She doesn't get to choose a job that puts her in a position where she can kind of, she's saying they're garnishing half my check, but when your check is $200, your $100 payment, that's the max child support can take from you. That's not reasonable. You're self-selecting a choice that's resulting in you being in contempt. So at some point she has to make choices that put her financially working full-time, even if she's choosing full-time minimum wage. So again, I think my client's been really reasonable and gracious in this matter, especially offering sort of a 4-month set over for her to get her choices aligned with what allows the order to be paid.
All right, so I appreciate Ms. Stockwell, the tax return information and getting that submitted. I got to tell you this. I'm sure everybody's frustrated. You can't squeeze blood from a turnip. Is that the old saying? I understand that. Your standard calculation being imputed at full-time minimum wage is twice as much as I ordered you to pay. So I already gave you a massive break. And there's more kids. And guess what? You're responsible for all of them. So you can't just leave 2 of them in the dust because of new ones and other ones. Your obligation has been $300 a month since it was set by me back on November 4th, 2022. If you wanted to petition for a recalculation of that, I can't give you legal advice on how to do that. That's obviously something that you can speak to someone about to look into. I don't know that you're going to get, for lack of a better term, a better deal than the one you got here, to be very, very frank. So here's what I'm going to do. I am going to set this out to, does December 5th, I think that's a Tuesday, December 5th, 2023.
That is a Tuesday. That works for me.
So December 5th, 2023, 1:00 p.m. for review. Reminding you again, your court obligated payment is $300 a month. I am going to impose $250 in attorney's fees. I'm going to ask that there no interest accrue on that until I'm going to give her 90 days instead of 60 before any interest accrues. And good luck with your birthing process and your new child. We'll see you back December 5th, 2023, 1:00 p.m.
And I'd just like to use that same date as presentation. Ms. Stockwell, I'll send you a copy of the order. If you're in agreement with it, I just ask that you sign off, just meaning that my order reflects what the judge ruled.
All right. Thank you. Good luck.